Okay.
Right, we are live and recording. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. This is the July 20th sitting of the Massachusetts Appeals Court. We have one case on this morning. My name is Vicki Henry and I'm the panel chief today. I'm happy to be joined by Justices Sachs and Singh. We will have the one case. The normal rules as if we are in a courtroom apply, even though we are here today on Zoom. So each side will have 15 minutes to argue with no rebuttal. If you notice us looking off to the side, that's because we have our notes on a different screen or even screens, and we're largely paperless. So we are paying attention. We're just, using any notes we have, or maybe we have transcripts or case materials available to the side. And so with that, I'll call the first case, which is case number 2020-P-1337, Commonwealth versus AL-MURAD. And Attorney Rosenberg, please start your argument.
Thank you, Your Honor. Sam Rosenberg on behalf of Mohammed AL-MURAD, and may it please the court. Your Honors, in this case, the district court erred when it denied Mr. AL-MURAD's motion for a new trial without an evidentiary hearing and even after a motion for reconsideration. Although the district court judge did not make written findings and the oral findings were scant, I'd like to start with the issue of trial counsel's ineffective assistance and then move to prejudice.
May I ask a couple of factual questions before you start there? In your motion to expedite, second motion to expedite, you said that the defendant had been ordered removed by an immigration judge and that was currently on appeal to the Bureau of Immigration Appeals or Board of Immigration Appeals. What was the basis of that order?
It was this case, Your Honor.
Okay, so it was not the indecent assault and battery case. Okay.
Correct, Your Honor. Under the Acosta case from 2018 in the Board of Immigration Appeals, I don't believe that they can move to remove Mr. AL-MURAD until his direct appellate rights are exhausted.
Yeah, so that's now happened. Our court, a panel of our court, affirmed the indecent assault and battery on a person under 14 conviction back in May. I understand you have a further appellate review petition pending, but that's not as of right. So, and at the hearing on the motion for new trial, you said a number of times that your client would be in a very tough spot if he lost the direct appeal. So how does that affirmance by our court affect this case? And does it render it moot in some sense or render any issues moot?
It does not render it moot, Your Honor. I think practically it puts him in a worse spot, of course. But legally, we have to focus on the time of the plea. I think Labernenko and other cases are clear about that. And I also think sort of blending the practical and the legal, Your Honor, who knows what will happen with that conviction, right? The immigration authorities haven't moved to remove him for that conviction. Maybe something else will happen and he'd still be stuck with this one. But I think largely, Your Honor, we have to look back at the time of the plea when we evaluate prejudice and special circumstances.
Okay. And then one other point of clarification, and I'm sorry to interrupt the train of your argument, but no. I thought we could get these out of the way. In your reply brief at page 8, you say, the Commonwealth is correct that Mr. AL-MURAD would be ineligible for cancellation of removal regardless. That means, and then you cite, you say because he hasn't resided in the US for 7 continuous years, but then you cite the subsection of 1229B that refers to having been convicted of an aggravated felony. Is it the case that even based on the larceny conviction, and even if he hadn't been sentenced to more than a year on that, that could be a crime of moral turpitude and would make him deportable regardless? I didn't understand what the basis was for your concession that he's ineligible for cancellation of removal?
So in the principal brief, Your Honor, I listed 3 sort of consequences of an aggravated felony that wouldn't necessarily apply to a crime of moral turpitude. 1, cancellation of removal was a bit of an arithmetic statutory error on my part, and I wanted to address that in the reply brief. But the distinction, so the Commonwealth was correct, but
So it is based on the fact that it's a crime of moral turpitude and hasn't been here for 7 years. It's those 2 combined?
yes, Your Honor. Yes, Your Honor.
Okay.
But the fact that it is an aggravated felony, Your Honor, does lead to does put him in a much worse spot than simply a crime of
Right,
moral
because of
turpitude.
the other 2 consequences.
Yes, Your Honor. And I apologize to the court for any confusion from that.
Okay.
So circling back, Your Honors, to the ineffective assistance issue, the court could have found plea counsel ineffective in 2 related ways. Under Padilla, plea counsel has a duty to give truly clear immigration advice when the consequences are truly clear. And sort of as a prerequisite for that, as Lavernenko and Clark and other cases make clear, that plea counsel has to make reasonable inquiry into a defendant's status. Relatedly, under the Mourinho case, plea counsel has a duty to advocate at sentencing, which also similarly requires that plea counsel make reasonable inquiry into a defendant's status. In this case, as Mr. Al-MURAD avers in his affidavit, and as I think comes through in the transcript of the plea colloquy, plea counsel did not make that inquiry, and that led him to not advise Mr. Al-MURAD about the truly clear consequences of his plea. And it also led him to not raise the immigration issue effectively at sentencing, when it does seem like there was a possibility that there could have been some middle ground to avoid the immigration consequences.
So your focus here is on the 2 consequences that you say follow from an aggravated felony that would not follow from merely a crime of moral turpitude. And that's the discretionary exception to the 1-year time limit on asylum applications, and the ability to apply for withholding of removal under the Convention Against Torture. The affidavit that the defendant filed just said, I wasn't advised about that a guilty plea could lead to my removal. Does he have to allege more specifically, I wasn't advised that if I pleaded to a crime or one of the alleged crimes that had a sentence of more than 1 year, I'd be ineligible for these 2 particular discretionary forms of relief? Because that seems to be the focus of your appeal now that we've seen the reply brief.
I don't believe he has to aver that in his affidavit, Your Honor, because if they didn't have these initial discussions about his status, there's no way they could have had these more detailed discussions about the consequences of an aggravated felony.
Right, that may go to the performance piece, but what about the prejudice piece?
Well, I think just sort of circling back to your previous question, an aggravated felony does put him in a much worse spot than a crime of moral turpitude. Even just the difference between withholding of removal versus deferral of removal is huge. In the reply brief, I cite the DOJ handbook, where they refer to withholding of removal as a much more secure form of protection than deferral of removal. In fact, if under deferral of removal, which he may still be eligible for, and it's the best thing he really is, he could still be even detained pending some sort of consequence or further investigation. So the fact that they are aggravated felonies, that's really the worst thing that he could have had. And if they were just crimes of moral turpitude, I think he would have still perhaps not been in position A, but he would have had these other options on the table that he doesn't have now.
And does there have to be an inquiry into how important those options are in practice? I mean, if I see on paper that the aggravated felony conviction makes him ineligible for this exception to the 1-year time bar on asylum applications, but if only 1 in 1,000 of those, or 1 in 10,000 of those applications for an extension is granted, then I'm just saying hypothetically, if, then how important is it that he wasn't advised about that? How important is it that he pled to an aggravated felony instead of just a crime of moral turpitude? And likewise with the withholding versus deferral of removal under the Convention Against Torture, don't we have to know how realistic in practice that possibility is in order to evaluate prejudice, and whether a reasonable person would have gone to trial instead of facing those.
I believe it's sufficient just to know that it would have put him in a better position if these weren't aggravated felonies. And I think that goes back to the List case, LYS, or even the Lee case in the Supreme Court, which is we have to look at it from his perspective. And where he views, I think reasonably, Iraq as a death sentence, right? If it could have improved his odds 3% had he gone to trial, right? And sort of thrown the Hail Mary, I think we could look at that as a reasonable choice given the alternative that he's currently faced with. So
just before you continue, am I correct in understanding that he is not contending that he had a substantial ground of defense to the charges?
You're correct, Your Honor. And just to sort of finish on the ineffective assistance of counsel point, Your Honors, based on Mr. AL-MURAD's affidavit, and again, the trial court, it's not clear. He didn't explicitly reject Mr. AL-MURAD's affidavit, so we don't really know exactly where the judge came down. But if there were any concerns, the correct course of action would have been to hold an evidentiary hearing. And although there was no affidavit from plea counsel, there were attempts by post-conviction counsel outlined in my affidavit to secure that affidavit from plea counsel. So that puts us in the Martinez side of the coin, where there were attempts, and it shouldn't be held as the main reason to deny a motion for new trial, and an evidentiary hearing is the correct course, as opposed to Cano, where we can draw negative inferences.
Sorry, would we really need an evidentiary hearing? I mean, would perhaps the proper recourse is simply to send it back for findings, for explicit findings regarding the credibility determinations based on the affidavits alone?
I believe that would be the first potential step, Your Honor. But I think at that point, if the court goes back and they say, I don't find this affidavit credible, I think then we still have the issue of how can you make that determination without an evidentiary hearing?
Doesn't the case law support the fact that judges can make that determination without an evidentiary hearing, simply based on affidavits?
It does, Your Honor, but it also holds that the best practice, if you have questions about the affidavit, is to hold an evidentiary hearing. So I think at this point, I think that would be one course of action. I think I'd suggest the better course of action would be to send it back for an evidentiary hearing.
So at least on the form of prejudice that deals with the possibility of negotiating a better plea agreement, your 2 points are, well, if he'd known, he might have negotiated an agreement that avoided the 1-year sentence and therefore preserved the late asylum application option and the withholding of removal under the Convention Against Torture. Does the, I'm sorry, I lost my train of thought.
Well, no. I can start to talk about the prejudice issue, Your Honor, and then maybe we can get back to it. So just to start out with prejudice.
Yes, okay, so here's the question. Are those the kinds of consequences that are quote unquote truly clear under Padilla? And maybe Lavrinenko is your best case at the state level about what kinds of consequences, short of you'll be basically subject to automatic deportation. Deportation is virtually inevitable. What case or cases stand for the proposition that counsel need to advise their clients about these more nuanced applications of immigration law, like, well, if you plead to something that involves a year or more sentence and it's an aggravated felony, then you'll be ineligible for a certain form of discretionary relief?
So I think there's two things, Your Honor. I think there's the first piece of advice that it is an aggravated felony, and that is worse, unquestionably, than a crime of moral turpitude and limits your options.
But worse because of these two consequences that you're pointing to.
Yes, Your Honor. I would say De Jesus deals with the aggravated felony statutes and says those are truly clear. So I think plea counsel, had they made further investigation, would have been able to find that these are aggravated felonies. And then they could
Which
have
case? I'm sorry?
De Jesus.
Oh, De Jesus. Okay.
Yeah. I believe that's from 2014. And I think at that point, if there's some question about, and this is obviously tricky stuff. If you're not a full-time immigration attorney, CPCS has an immigration unit. So I think had counsel made the first step and had they maybe advised him as to 2 of the 3 consequences and then maybe missed the 3rd or something like that, I think it would be a very different conversation.
Okay, but what case, I guess, says an immigrant, in order to advise his client properly, counsel needs to know that an aggravated felony means you can't apply for the asylum late, and that you'll only be eligible at most for deferral of removal rather than withholding.
I'm not sure, Your Honor, there's a case that directly says that.
Or consequences of that level of granular detail about the nuances of immigration law that it seems very difficult for ordinary defense counsel to know about and keep up with.
I believe that it would be a combination of DeJesus and Lavernenko, Your Honor, would be my best answer right now. And I'll have to look back through my notes and perhaps submit a letter to the court afterwards if I find something better. And just to sort of round out the prejudice argument, Your Honor, I think the biggest problem with the trial court's finding on prejudice is they didn't consider the special circumstances at all, which puts us directly back in Lavernenko. That's exactly what happened in Lavernenko, basically, is the trial judge didn't make findings about special circumstances, and this court sent it back with a suggestion that there were potentially special circumstances. So that, combined with the fact that the court's findings about alternative plea bargaining were sort of based in retrospect and not based on the plea colloquy, I'd say that, and I see I'm running out of time, Your Honor, but we would just ask that you either reverse and vacate his convictions or send back for an evidentiary hearing. Thank you, Your Honors.
Thank you. So Attorney Rosenberg, I know we had a lot of questions. Was there anything important that you didn't get to say to us?
No, Your Honor, I don't think so, Your Honor. If I hope I answered your questions as best I could.
Okay, thank you. Attorney Solis?
Good morning, Your Honors. May it please the court, Abigail Solis on behalf of the Commonwealth. Judge Pellegrini correctly determined that the defendant failed to prove that he suffered prejudice from plea counsel's purportedly ineffective assistance of counsel.
So he didn't issue written findings, but his suggestion from the bench was, well, there's a very, very slim chance in any event that I would have crafted any disposition around immigration consequences, be it a 364-day sentence or 3 7-month consecutive sentences. He said that at the hearing, but what legitimate sentencing goal or other rehabilitative goal of the criminal justice system or punitive goal would it have served if defendant had proposed those options for the judge to say, no, I'm not going to give you 364 days on this, I'm not going to give you 3 consecutive 364-day sentences or 7-month sentences. I'm going to give you a single 1-year sentence. Basically, all I can see being achieved by that is that it makes some of his offenses into aggravated felonies.
So it's a common misnomer, this 365-day issue. So it's the length of the sentence that's actually imposed is not determinative of immigration consequences. It's the nature of the offense and the sentence that may be imposed for that offense.
Let's assume that it's, at least as far as aggravated felonies goes, it's the length of the sentence that is imposed rather than what could be imposed, because I think there is law standing for that.
So that
just assuming, and we'll verify that and we'll look at all the sites in your brief, but assume that that's what makes the difference between an aggravated felony and a non-aggravated felony, even if it might also be a crime of moral turpitude.
So some aggravated felonies, for example, the sentence has nothing to do with it. So for example, a sexual assault, drug distribution, things like that. For a theft offense, such as this case, it's both. So a theft offense that has a sentence that, and this, I know you've read my briefs, but the federal statutory language is a crime for which a sentence of 1 year or longer may be imposed. That's the direct statutory language. And in this case, defense counsel did ask for 6 months, and the Judge Pellegrini was fairly vocal about that not being an option and the seriousness of the offense. And he was not even inclined to do a year until the defendant was able to pay restitution to the victims who were present at the plea hearing. So he did ask for that 6-month sentence, but again, that wouldn't, under the statutory language, that wouldn't have made a difference because the sentence that may be imposed for the offenses is a year or more. I hope that answers your question.
Well, but if it really is the 365 days, then what do we do with the fact that plea counsel didn't even propose 364 days or propose multiple 364 days, but served consecutively so that the incarceration would have in fact been longer, but would have addressed this issue?
I guess that's what I'm arguing, is that it wouldn't have addressed the issue. The result would have been the same because this is an offense that is punishable by a year or more sentence. So it wouldn't have mattered what the judge actually imposed based on what the statutory language said. And again, reading the plea transcript, he asked for 6 months and the Commonwealth was asking for 18 months. The judge was saying he was inclined to do 18 months. So it wouldn't have made sense to then ask for less than a year sentence based on the conversations that were happening at that plea hearing. So based on my first argument, if I may, I'd like to mostly focus on the prejudice piece, but I'll start with the ineffective assistance of counsel briefly, if I may. This is a case that the judge had, excuse me, the judge had the benefit of the plea transcript. A lot of times in these cases, they come back a lot later and we don't have the plea transcript. In this case, looking at the transcript, plea counsel indicated knowledge that the defendant came to the United States as a refugee. He stated that he spoke with the defendant about immigration consequences and maximum penalties, and the defendant agreed to that, and that's in the transcript. We also have the same judge. So Judge Pellegrini heard the plea as well as the motion hearing, and for that reason, his decision is entitled to greater deference, and that's the Kolanovic, sorry, I'm probably mispronouncing that, case. So as far as
I'm sorry, I want to go back to the issue of sentence imposed. Could be imposed versus sentence actually imposed.
Yes, Your Honor.
Commonwealth versus Gordon, 82 Mass Appeals Court, 389 at 397 says an aggravated felony according to 1101 A43F includes a crime of violence for which one is sentenced to at least 1 year of imprisonment. And either that case cites, or I have the cite from somewhere else, 11th Circuit case saying an aggravated felony is defined by the sentence actually imposed, citing a 3rd Circuit case. So what language do you rely on saying that it's the sentence that could be imposed?
Yeah, so I'm looking at the federal statute. It's 8 USC 1227, section A2A, and it says an alien convicted of a crime of moral turpitude within 5 years of entry, 10 years if they're a lawful permanent resident, and is convicted of a crime for which a sentence of 1 year or longer may be imposed is deportable. An aggravated
right, that's if it's a crime. That's if it's a crime of moral turpitude. Well, no, but that doesn't make it an aggravated felony.
No, the second part of the sentence says aggravated felony is deportable at any time, because they're just delineating time of entry in that. So it's this. That section of the statute addresses both crime of moral turpitude and aggravated felony. In this case, because it's a theft offense punishable by a year or more, is both, sort of like the Valdez case. So the Valdez case was a car theft, and the SJC in that case said it was a crime of moral turpitude because it was a theft, and it was an aggravated felony because it was punishable by 1 year or more.
Okay.
So sorry, go ahead, Your Honor.
Sorry, I guess I'm missing. How are you making the connection between a sentence actually imposed of less than a year and an aggravated felony? I see 1227 A1
A2A.
A2 A1 A2A.
Sorry, no. So it's 1227 A little a to big A. And that's actually cited easier. It's the statutory language is cited on page 22 of my brief.
Okay.
So that's why we're in the realm of prejudice now, so I'll just go with this section of my argument. So as was stated earlier, the defendant does not claim that there is a substantial ground for defense. So practically, realistically and in practice, if he were to win on the motion for new trial, there's, video surveillance, there's a number of eyewitnesses, there's photographic evidence. So if he were to go back and get a new trial, he would most likely be convicted and then he'd be in the same boat. Also,
right, but his argument is I would rather stay alive longer, even if I'm incarcerated.
So, well, no, he would be deported because if he was convicted, a conviction is whether it's a plea or a conviction by a jury, he's still deported, I guess is my point. And that, of course, goes to the credibility of the defendant's affidavits, with which, of course, the judge had discretion to weigh that credibility. So looking
But see, we don't know. The problem is we don't know about that credibility determination. So do you agree that it goes back at least for explicit findings regarding that?
Of course, it certainly would be nice if we had written findings, but looking at the Furr case, FURR, the court said that a judge may decide a motion based solely on submitted affidavits, and the weight and credibility of those are in his discretion.
But we don't know that he did. He could do that, but should we just assume that he did, even without him saying so?
Certainly written findings would have been preferable, but this is a case where this judge handled the plea hearing as well as the motion hearing. So the plea happened in front of him. He was there for it. I was looking
we don't have an oral finding either, right? There's just no finding.
No, it's just unfortunately, it's just a notation on the motion denying it.
So the notation as well as the colloquy or the hearing gives us nothing from which to understand whether he considered special circumstances, right? There's nothing from which we can take away that he considered this special circumstances.
No, there isn't. I think regarding the special circumstances, again, all we have on that is the defendant's self-serving affidavit, which the judge was not, didn't have to credit that, especially where the defendant, I'm looking at appellate counsel's affidavit, it said, which is at record appendix 51, the defendant expressed shock at the immigration consequences, as if he'd never heard of them. But if you look at the plea transcript, it says plea counsel indicated knowledge that defendant came as a refugee and stated he spoke with the defendant about immigration consequences and maximum penalties, and the defendant agreed. So then in an affidavit to say, I've never heard of this before, I mean, clearly the judge would have been well within his discretion to not credit those representations in the affidavit.
I'm
So
sorry.
are you saying it doesn't matter if the judge credited it or not?
No, that's not what I'm saying. I'm saying that it would have been well within the judge's discretion not to credit it, especially where those are the lines in the plea transcript and they just don't square with what the defendant is representing in his affidavit.
Well, I mean, one is what one is defense counsel's sort of representations versus the defendant's understanding. They're two different things. It's not as if one necessarily contradicts the other when it's two different people's perspectives.
I understand that, Your Honor. Appellate counsel is saying defendant told him he had no idea. The plea transcript certainly would suggest otherwise.
Well, but I mean, part of the issue with the plea transcript is it says that this is the judge. The judge says if federal law required it and if officials seek it, so it's conditional.
Sure. Yes, that's true. If I may, I see that I only have a few minutes left. I'd like to touch on briefly the Convention Against Torture and the, and the
Asylum petition.
Sorry, yes, the application for asylum. So thank you, Your Honor, for giving me my words I was searching for. regarding the application for asylum, so the DOJ fact sheet that I appended to my brief, an alien must file within 1 year of date of last arrival. So he arrived in this country, Mr. AL-MURAD arrived in this country in 2014. And if someone wants to apply later, they need to prove changed or extraordinary circumstances that make the delay reasonable. And the defendant hasn't said that there's any reason why he would have waited this long to apply for asylum. So this case has no bearing on the application for asylum. Regarding the Convention Against Torture, so he would be barred based upon the withholding of removal under the Convention Against Torture. But as far as deferral, which, as my brother stated earlier, is not as strong, he would not be prevented from doing that. And in order for him to be removed, if he had gotten deferral of removal under CAT, the government would have to show that he's no longer at risk of being tortured in his home country. So there would be a burden on the government to show that in order for him to be deported. So it is an additive layer of protection that's significant.
Do you agree that these are the kinds of consequences under Lavranenko in particular, of which competent counsel has to be aware and inform his client?
No, Your Honor. These are, as Your Honor described them before, they're more granular consequences. And the Padilla and all of the cases that come from Padilla are about mandatory deportation. That's
sure, except Lavranenko says the denial or the risk of denial of a discretionary form of relief is enough. And the fact that it was merely a risk rather than certainty doesn't make it any less truly clear. As a matter of Article 12, regardless of what federal law about ineffective assistance might be. So by that standard, how is this different from Lavranenko in terms of counsel's duty?
So this case is quite different from Lavranenko and also from the Cano case that my brother cites too, because those cases, those individuals were refugees at the time of the plea. This individual was not. So their special, case law tells us that refugee status at the time of the plea is a special circumstance. That's not this case. Those cases also had affidavits that were from other individuals. So from plea counsel, from Cano, for example, had a doctor's affidavit. So those cases just aren't the same as this one, and those distinctions are important.
Why is that case not this case?
Sorry, Your Honor, are you asking about Lavranenko or Cano?
No, you're saying that he's still a refugee, right?
No.
He may not have that legal status, but he's still left Iraq because, or alleges that he left Iraq because of the fear of being murdered by people who were against cooperation with U.S. military.
So I'm certainly compassionate to this individual's, what he alleges happened to him in his home country. However, the case law is about legal status at the time of the plea. So in this case, the defendant entered the U.S. as a refugee. In 2015, he was granted lawful permanent residency or green card status, and that goes back to his date of arrival in 2014. So he was not legally a refugee at the time of his plea. Lavranenko, the individual was, and the court has established that refugee status is a special circumstance. And again, the outside affidavits matter. So there have been cases, for example, that where a defendant has been tortured, a doctor has provided an affidavit that injuries were consistent with torture. Or in Cano, there was a case, it was about competency of understanding the implications of a guilty plea, and there was a psychologist who provided an affidavit. Here, all we have is the defendant's self-serving affidavit that this is what happened to him. There's nothing from a family member, there's nothing except for his word to go on that he had this threat in his home country. And again,
he was able to come here and get a green card very quickly.
He was. And again, as far as protections from going back to his home country, he can still apply for deferral under the Convention Against Torture. And I know we're out of time, but I also want to mention he also has this conviction for sexual assault on a child, which renders him deportable. So practically speaking, he doesn't have a lot here. except for the deferral of removal under the Convention Against Torture.
May I ask, and I'm sorry to go back to this, but I think it's an important point
Sure.
about whether it's the length of actual sentence versus the sentence that could be imposed. I'm now looking at the section you cited in your brief, 1127A2 big A. And I see that big A sub 1 defines crimes of moral turpitude, and that clearly includes crime for which a sentence of 1 year or longer may be imposed. But then there's a separate definition of aggravated felony. Well, it doesn't, the definition isn't in that section, it's elsewhere. But what makes you say that this statute makes the crime of moral turpitude automatically, what makes the crime of moral turpitude here also an aggravated felony?
Okay, so this is, I'm happy you asked it this way because I think this is the clearest way for me to explain it, hopefully. So that section, so a theft offense is always a crime of moral turpitude. So shoplifting, any theft offense. If, in that little sub A you mentioned, if it is punishable by a year or more, that theft offense then becomes an aggravated felony.
Well, I see that it makes it deportable.
It becomes an aggravated felony.
Well,
If there is
maybe
a-
we're
it's
looking at different
punishable by a year
statutes.
plus.
I'm looking at pages 88 and 89 of the addendum to the defendant's brief. And it says crimes of moral turpitude. Any alien who is convicted of a crime involving moral turpitude within a certain time and is convicted of a crime for which a sentence of 1 year or longer may be imposed is deportable. This is about what's deportable. And then
Yes.
in sub 3, it says any alien convicted of an aggravated felony is deportable. But I don't see what makes the connection between a crime of moral turpitude for which a sentence of 1 year or longer was not imposed. I don't see what makes that into an aggravated felony.
So some aggravated felonies, I hope this answers your question. Some aggravated felonies are mandatorily deportable regardless of the sentence. A theft offense only becomes mandatorily deportable if it has a sentence of a year plus.
Okay, so which crimes, taking moral turpitude out of the equation, which of the convictions here was an aggravated felony regardless of the length of sentence, of the actual sentence?
The sexual assault.
Okay, so you're not saying the crimes in this case, you're saying the crimes in the other case.
No, because this,
I'm
sorry.
saying his other trial court proceeding, the indecent assault and battery on a child under 14, that is an aggravated felony regardless of the length of sentence actually imposed. But here
Correct.
we're dealing with two attempts to, break into and steal from mosques, and he pled to a series of offenses. Are any of those aggravated felonies regardless of the?
Yes, because they are punishable by a sentence of a year or more.
And what
Because
language?
that's what makes them cross over from crime of moral turpitude to aggravated felony, because there is, for example, if it was shoplifting and he got 18 months, it wouldn't matter because that's not punishable.
Okay,
by a
but
year or
putting
more.
aside the crime of moral turpitude, what makes any of those offenses, what language makes any of those offenses into an aggravated felony regardless
Any of which offenses?
Breaking and entering in the daytime with intent to commit a felony, breaking a depository, I can't remember what the third,
The larceny.
other than the
Yeah.
vandalism and the things like that kind of went away.
Because the statute says that a sentence of 1 or more years may be imposed for that offense. That is what makes that an aggravated felony.
And what part of federal immigration law says that where a sentence of 1 or more years may be imposed,
The
that
part you
makes
just
it,
read about the part you just read earlier.
that's about crimes of moral turpitude, and that defines whether they're deportable, not whether they're aggravated felonies. This is where the disconnect or the problem that I'm having.
So it's, I feel like I keep saying the same thing
Well,
and I'm not
maybe I don't want to
understanding it well.
take up
I'm
everybody's
sorry.
whole day with this, but maybe you could.
I'd be happy to, if it's easier to understand, if I outline it in a letter, I'm happy to do that for the court.
I think that would be helpful.
Okay.
I'll defer to my panel mates on that.
Thank you. That would be helpful.
All right. And
I did have one further question.
oh, sorry, Justice Henry.
Well, your learned colleague has said that we should not be looking at the indecent A and B under situation as of today. We should be looking at it as of the time that the motion judge made his decision. I just wanted to know what you say to that.
I would, and I didn't cite this regrettably in my brief, but the Hernandez case that came out recently in 2019, it's an SJC case. You know, we don't have the doctrine of abatement. The guilty verdict is the final judgment. So consequences may be imposed even if an appeal is pending. I don't know if anecdotally, if ICE is deporting somebody when an appeal is pending, and if they win, they're bringing them back. I don't work for that agency. I don't know. But that's a guilty verdict. It's a final judgment. There's a presumption of guilt attached to, you know, a final judgment. And yes, at this point, that judgment is on an application for further review, and we'll see what happens with that. But I don't see that, you know, changing the Commonwealth's argument in this case.
All right. Thank you very much, both of you. I think I think with your supplemental letter, perhaps we will have better understand your positions, but well argued. And we do have your briefs and materials.